in the YSL trial. The defense is in full-blown attack mode, so at any moment, a new motion might pop up. And this afternoon, this evening or whatever, Max Shard put in a new motion. So it's a 21-page motion, and I started reading through it. I didn't read everything, but I'm going to read through the rest of it with y'all today or this evening so we can figure out what's going on in this thing, what Max Shard is saying. I know that Max Shard put his motion in for a fair and constitutionally fair trial, and he feels his client has not gotten that so far to this point. He knows that Judge Whitaker will be fair going forward, but he's saying, hey, I'm looking for remedies for the past inconsistencies when it comes to a fair trial. That's almost like looking for, that's really like he's looking for what happened in the Alec Baldwin trial. You know what I'm saying? Where it's pretty much like, hey, I see all of these issues with the constitutionality of some of these rulings, with some of the behavior of the judge, with some of the behavior of the prosecutors. And the only way to remedy this type of constitutional violation is with a mistrial without prejudice. So that's what he's really looking for. But we'll see if how this judge just seems to be. You know what I kind of feel like was a mistake, and this is we could brush through some of the stuff, but I feel like it was a mistake a little bit in hindsight, because at first I didn't think it was a mistake. In hindsight, looking at Mr. Harvey's motion saying that Judge Whitaker couldn't possibly take over this trial after 19 months, not knowing what's going on, all that, I think it was kind of a mistake in hindsight, because now it seems like Judge Whitaker is kind of taking it like a challenge. Did anybody else get that vibe? Whitaker is taking it as a challenge, like, oh, you don't think I can catch up in the middle? You don't think I can read all these transcripts and pick up where y'all left off? You don't think, it's almost like she's taking it as a challenge to her intelligence. That's the energy I'm getting from her now after that motion. Because now she just seems like everything is like, okay, when we get back, it's almost like she's planning post mistrial motions denied, pretty much being denied. So, anybody else getting that vibe? Because I'm getting that vibe that the judge feels like she's been challenged, like her professional intelligence has been challenged. So y'all let me know what y'all think. Nessie, I see you say you agree. I'm assuming you agree with what I just now said about the judge feeling challenged. Let me see some of these comments before I get into everything. Let's see. Clayton started yesterday. Yeah. APS started yesterday also. Atlanta Public Schools. Hip East, I'm so glad I don't have school kids. Mine are grown. Blue skies, when the judge laughed at love, I fell out. Mistrial with prejudice. Okay, I said it wrong. Okay. So and thanks for the correction, Hip East. If you're correct, I don't even know if you're correct, but I'm gonna just say thank you for pointing out that we have different ideas or different point of view on which one it is. But so let's just go to, so pretty much Monday they were still off, and then Tuesday they came back, and there was just a whole heaping of motions to get through. And listen, judge got court going. It was crazy because I didn't get to turn on the trial till like 9:15, and I was pleasantly surprised that I was 30 minutes behind already. So that's amazing. I love prompt anything that's punctual. I'm fully with it. So that was great to see. The judge was a man of her word, or she was a woman of her word, whatever you want to call it. And she made sure, when I sit down in the seat at 8:45, that's what time court starts. Y'all better be here. And she meant that. And they started on time every day this week, pretty much. So, and even if you're a few minutes behind, that's fine, like 5 minutes, whatever, 3 minutes, 30 minutes and 2 hours that's where things get crazy. You know what I'm saying? So, shout out to her for being like that. So they come through Tuesday. Whitaker lets it be known off top, I'm not redoing anything Judge Krause did. I'm not re-ruling on anything. She did grant your motion. You just didn't like how she characterized it. So like I'm not dealing with that. She pretty much like got that done off the rip, right? So then, and I thought that it was interesting because they kind of looked into like the disqualification motion of Hilton and Love, but she was like, I'm gonna look at it, but I'm not gonna make a ruling today. She was like, maybe I'll make one tomorrow, but I'm definitely not doing it today, right? So eventually this week, and we can jump ahead a little bit, eventually this week she did make, it was later in the week, she did make that ruling on a disqualification motion. And of course, she denied it. Let's look at what she said, though, a little bit. Give me a second. Let's look at what she said here. And I think she denied it really based on. Hopefully y'all can read that. But let's read a little bit of what's going on here. So pretty much, Defendant Williams asserts that that prosecuting attorneys Love and Hilton must be disqualified from the case because they are critical witnesses in the case. Defendant cites Miss Love's exchange of text messages with the witness and both prosecutors participating in a June 10th ex parte meeting with the then trial judge, a state's witness's attorney, arguing that they must be examined so that the jury can consider whether the predecessor trial judge was biased for the prosecution in this case. Okay. Essentially, the reason that she denied it, right? And I'm gonna give me a second. I'm gonna pull up the next page. That's where it kind of explains it better at. That's what explains it better at. And we are gonna look at that now, right? So if you look at the So pretty much it says here that the other evidence is available. The text messages at issue were introduced at trial, and the witness has already testified. Transcript of the June 10th ex parte transcript has been filed. So there are other sources readily available to establish the content of all the matters cited in the motion. So pretty much the judge is saying, and there's case law for it, pretty much saying that you can't compel a prosecutor to be disqualified because you want them to testify when the things you want them to testify about are available to you already. Pretty much the ex parte transcript, the emails, text messages, all of that stuff is already available to you. So you don't need them to come forward and say it on the stand because you can just use the evidence to get in whatever you need to get in. So that's pretty much what the judge. So it sounds to me like maybe this motion wasn't properly structured. And that's not for me to be questioning anybody's legal acumen here, especially not somebody as seasoned as Brian Steele. But just based on the denial motion, it looks like the judge is saying, based on what you asked for, I don't have to disqualify them for that because you have what you need. Everything that you can ask her about is right there in the evidence that you have, right? Please like the video. Please subscribe to the video. Okay. So that happens, but that's later in the week. So I'm still at like Tuesday or whatever. So then the judge is like, let me see. The judge denied Harvey's motion. So the judge is going to also, so again, the judge denied the motion from Bruce Harvey, pretty much saying that it's been 19 months since the trial started. How could you possibly take over this case? And we seen later on in the week when the judge is trying to learn people's names, like defendants and witnesses and co-conspirators and all this. She doesn't know their name. And Harvey brings it up again. He's like, pretty much, this is what I'm talking about. You don't even know who these people are. In 19 months of trial, everybody in here is pretty much an expert on gangs and YSL, co-conspirators, their friends. We all know who they grew up with. We all know who knew who first. All of us who have been paying attention to this trial since the beginning, we all have that information, including the jurors. But you, Miss Whitaker, are the only person in this entire equation that has no idea what's going on. So I think he had a good argument, but like I said, I think the judge took that as a challenge. I don't think she really, you know what I'm saying? I don't think she liked that he was on that. And she denied that. She denied that motion for sure. She did not end up ruling on Weinstein's motion for mistrial because she wanted to take more time on it. I don't know how long she's going to take to go through everything and decide. Now, part of me thinks that she does plan on granting a mistrial. Then part of me thinks that she wants to just go forward with it. I can't get a good gauge because I can't understand what's taking her so long to get the Weinstein's motion. She wants to move forward and like go over all this evidence and stuff like that. So now the court agrees, the state agrees, the defense agrees that everything that Copeland testified to and every argument that they had after June 12th is all now dead, and they're gonna do it all over again, which is crazy. But they're gonna do it all over again. They're gonna give some jury instruction to say, hey, disregard everything, which I don't think you can disregard. Here's one of the first things I don't think you can disregard as a juror member, right? If you remember, first couple days, they had Copeland answering questions, and he was answering, whatever. There was like then the week ended, and then they started, I think, again on Monday, and they didn't ask him anything. They just started playing interrogation room videos in front of the jury, right? They were playing those videos because these were supposedly allowed in or admissible. The all full hours long of these videos were admissible based on Glanville agreeing with the state that these were prior inconsistent statements, right? So Max Shard got up, he objected. He said, hey, judge, these are not, you can't play the whole thing because it's a prior inconsistent statement. You need to play only the part that is a prior inconsistent statement. You can't play a 3-hour, 4-hour, 5-hour interview because something in there is a lie. You need to play exactly the part. And Shard, he objected. And the judge, Glanville, was like, no, they can play all of it because Copeland said that he lied about everything, right? Today, they were having a conversation about that, and Judge Whitaker actually agreed with Max Shard's argument about that it was the exact same argument, but Whitaker actually agreed with Shard. She told the state, yeah, you can't play 2-hour or 30-minute or any long video or any long interview just because of a prior inconsistent statement. You need to find a statement, play that, or argue why you should be able to play it, and then we'll go from there. But we're not about to listen to 2-hour interview because one thing in there or 2 or 3 things in there is an inconsistent statement. Him saying that I lied about everything is not the inconsistent statement. But Glanville took that as the inconsistent statement, even though that's not the statement. But so anyway, Whitaker agreed with Shard on that one. So now we're talking about hours and hours and hours worth of interrogation room video that the jury's seen, that somehow they're supposed to erase from their memory and go forward with the trial and re-listen to argument as if they never seen that video or as they've never seen hours of videos. Because like I said, when they came back to court that next Monday, I think it would have been the 17th of June, I think. When they came back to court, they didn't ask Woody nothing. They just started playing videos, right? So this jury probably heard 10 hours worth of videos over the next 2 or 3 days, right? So I don't know how the judge is going to go forward. And that's pretty much why they're about to be dealing with motions for mistrial into oblivion, because how's the defense going to get over that? I don't know. The state seems to have whittled down their list of witnesses to 105 people left after Copeland. Let's see what else we got here. 105 is still crazy because we've been going 9 months worth of testimony right now, and they only had around 75 witnesses. So I don't know, man. The judge still says she's probably going to knock that list down for them since they can't seem to get it down lower than that. Anything that's considered cumulative, she's going to get rid of it. Another thing that the judge was saying earlier in the week, and I haven't heard her say it today, she kept saying, if we get to that point, if we get to that point, we'll deal with it if we get to that point, meaning if there's not a mistrial. But she just kept saying it. It just kept making me think like maybe she is like leaning towards a mistrial in this whole thing. Let's see here. I'm reading notes right now. That's why I keep looking over here. Oh, so they would get into a little back and forth. The judge was asking, so Brian Steele came up. He was saying that, hey, judge, we already went over this argument already, and we went over it multiple times, and the state keeps bringing this thing up over and over again, and we already went over it. It's over. The judge asked the state, hey, have you gone over this before? And Attorney Love stands up and says, no, judge, we haven't. And after this whole no, we haven't thing, no, I didn't do that. I did this other little thing. Then the judge has to remind Miss Love, hey, Miss Love, please remember your duty to be candid with the court. pretty much, I read all the transcripts. I know you're lying. Please stop lying to me because I don't want to have to do you like that. And then Miss Love got up and said, pretty much, I resent the idea that I'm not telling the truth. And please don't direct it at me. Direct it at everybody in the court because I'm telling the truth. But we all know Miss Love is bending the truth more than an Olympic gymnast right now. Shout out to Simone Biles and Suni Lee. So she had to tell her that. Judge tells the state that they need to have 30 witnesses. Okay, so yeah. Then the judge instructs the state every week until y'all give me all the witnesses. Every week, y'all need to turn over 30 witnesses to the defense and lay out every single piece of evidence that'll be used with each witness. She pretty much said, y'all should have did this already anyway. This trial by ambush thing is not cool. Y'all should have already done this. We shouldn't be doing that at this point. But since y'all haven't done it already, I'm going to give you every week, you need to have 30 people and all the evidence that's associated with those 30 people, turn it over. So now if they wouldn't have done that, if Glanville told them to do it and they didn't do it, then they just wouldn't have done it. It would have been whatever. I got a feeling that if this judge tells them to do that and they don't have all of those witnesses turned in within the next few weeks, 30 per week, I got a feeling that there will be consequences. But stay tuned. We'll see. We'll see how serious the state takes this judge because they were not taking Glanville serious at all. So essentially, if they have 105 witnesses left and they have 30 a week, then that means they have 3.5 weeks to get all of that information over to the defense. So the judge is running through everything right on Tuesday, and then they get to like 3:00 and she's like, "Yo, I did so much. Like, give me something else to do. What else can we do here?" So then they just run around looking for something to do. Another thing I noticed on Tuesday, and this was the first day where they were like actually doing arguments and stuff like that. When Whitaker was making a ruling or saying like, "This is what it is. This is how we're gonna move forward," there wasn't a whole lot of argument. When Glanville made a ruling, the state would argue back and forth like Miss Love would just not stop. She just kept going. She wouldn't stop. Specifically, Miss Love, Hilton did it a little bit too. Sometimes the defense did it too, but it was mostly Miss Love. She would not stop arguing with Glanville, like just wouldn't stop. With Whitaker, she says it and it's over. Everybody is done sitting down. So I don't know, like, what's her reputation in Fulton County, or if they just are, everybody's like walking on eggshells because they know how fragile the structure of this case is now, and at any moment the floor can fall from under us. So I think everybody's just like on eggshells. So that's Tuesday. You know what I'm saying? That they did that thing. So now all of us as viewers, now we see. Okay. Now we see how Whitaker is about to run this thing. So now, like I said, with the thumbnail, we got a new sheriff in town, right? So then Wednesday gets here, and Max Shard pretty much kicks it off by going off on court, talking about how his bald head is steaming because he found out because Judge Whitaker forced the state to Brian Steele put in a motion to say, we need the state to give up every transcript for every ex parte meeting that has happened throughout the duration of this case. We need all of it now. Because now that y'all had this June 10th meeting, we don't know what kind of stuff y'all been doing this whole time. So then we go back and find out there was a June 7th meeting also about the pretty much same thing. There was a June 7th meeting, ex parte meeting that the defense had no idea about between Love and Glanville. Right? And it was pretty much about Copeland and his attorney and whether or not the attorney was providing good legal advice to the witness or not. And he didn't have his best interests in mind and all this type of stuff. So yet another secret ex parte meeting. But we find out today that the meeting was not actually a complete secret to the defense. So the Judge Whitaker said, hey, actually, if you go back to the transcript from June 7th, and you go to page 95, Ms. Love actually says out loud that she needs to have a meeting ex parte to talk about whatever. Y'all don't know the contents of the meeting, but you knew that there was an ex parte meeting. So the judge pretty much said, it's not this whole salacious thing y'all are trying to make it out to be. It's not that. Yes, there was an ex parte meeting. Yes, y'all didn't know the contents of it, but you definitely knew that there was an ex parte meeting because it was on the record that she wanted to have one. And it was also on the record that you, defense people, spoke after that. So y'all knew about this. So the judge kind of shut him down and like calm down a little bit with this June 7th thing. Like, I know y'all mad about it, but calm that down a little bit, right? So now, of course, the contents of the meeting is another conversation, but don't act like y'all didn't know about it, right? Now, Wednesday was like a light day, I feel, right? But I do think that them finding out about that June 7th meeting was crazy because what they found out Glanville was in there saying. So, Doug Weinstein got up and said some things about how he had been defending Glanville this whole time, and now he's been made to look like an idiot because Glanville actually wasn't impartial. He was actually biased as hell. So it was a lot of, performative. And he even got up and said, hey, I'm not being performative. I really am mad, guys. So, whatever. Then Brian Steele comes back later on in the day. I thought that he had a good argument, but I guess, legally, it wasn't good enough. Brian Steele brings up the fact that in a RICO indictment, not only do you have to show that there's a RICO, like a conspiracy, but you also have to show that each member willingly joined and participated in the conspiracy, right? So it can't just be enough to say, like, I was helping, think about the Brett Favre thing in Mississippi where he was taking money, right? If Brett Favre didn't knowingly get in this scheme with these people, the fact that he received some money is not a conspiracy. Like, he didn't know he was part of a conspiracy type of thing like that, right? I'm not saying Brett Favre didn't know, but I'm saying he wasn't charged like that because they're kind of asserting that he didn't know. That's what Brian Steele is saying. You can't just say somebody's in a conspiracy if they don't know. You have some people in this case that either had no direct conversation of Young Thug, or Young Thug didn't even know personally at all, but because one time they told a member of YSL something about a crime one time, now y'all are putting them in YSL and making them a co-conspirator with Young Thug, a music artist. So that's what Brian Steele is saying. Like, the law says that you have to put this wording in here, and you have to show how these people knowingly and willingly joined in the conspiracy. I thought that he even said, I even went and read some other RICO cases that were drawn up by the same Fulton County DA's office, and those cases had it in there. But this case, it wasn't in there. So he was saying that the indictment itself, in his words, fatally flawed, right? It didn't have the components needed to make it a RICO. The judge denied that. The judge was like, the judge pretty much said there's other wording in there that'll let you imply that the rest of it or let you know that it's implied. So pretty much they didn't have to explicitly say it. It's implied, and that's good enough. Move on. I thought it was a good argument. Like, y'all let me know. I thought he was cooking with that one. I'm not gonna lie. But I guess that was one that Glanville had turned down or also denied very early, and he didn't even want to hear it. So now they had a break on Thursday, and they came back on Friday. And, by the way, the judge denied that, and then Brian Steele filed for a certificate of immediate review, and she denied that also. So they are working at light speed right now, really, because Whitaker said that when she denied his motion, Brian Steele filed the certificate for immediate review within like 5 minutes, and then I seen that she denied his certificate of immediate review pretty much immediately after he filed what he filed. So Whitaker is matching speed she's going band for band, as the kids say. Now, excuse me.